Good evening, everyone. My name is Jan Patrick Mundihar of Section F. Today, I will answer the final examination of CLG 400. Number 1. Define evidence and explain its scope. Evidence is the means sanctioned by these rules and ascertaining of judicial proceeding the truth respecting a matter of fact. Scope. The rules of evidence shall be the same in all courts and all trials, hearings except otherwise provided by law or these rules. Number 2. What are the three kinds of evidence? Briefly explain each. First is object of evidence. Are those addressed to sense court when object relevant to the fact in issue, it may be exhibited to examined or viewed by the courts. Number 2. Documentary evidence. Documents as evidence consist of writings, recordings, photographs, or any material containing letters, words, sounds, numbers, figures, symbols, or their equivalent, or other modes of written expression offered as proof of the contents. Photographs include still pictures, drawing, stored images, X-ray films, motion pictures, or videos. Number 3. Distinguish corroborative evidence from cumulative evidence. Corroborative evidence is additional evidence as different kind of character tending to prove the same point, and it is a piece of evidence that may be derived from various sources but proves a common point. Cumulative evidence is additional evidence of the same kind of character tending to prove the same point. This is purely accumulation of similar evidence that is derived from common sources. Number 4. What is prima facie evidence? Is evidence which is unexplained or uncontradicted is sufficient to sustain a judgment in favor of the issue it supports. Otherwise said, if opposing party does not offer an explanation and present contrary evidence, then the prima facie evidence will be enough basis for the court to rule favor of the party that offers the prima facie evidence. Number 5. What is a dying declaration? In Section 37, dying declaration, the declaration of dying person made under the consciousness of an impending death may be received in any case wherein his death is the subject of inquiry as evidence of the cause and surrounding circumstances of such death. Number 6. What about statements uttered part of res gestae? Section 44. Part of the res gestae statements made by a person while startling occurrence is taking place or immediately prior or subsequent thereto under the stress of excitement caused by the occurrence with respect to the circumstances thereof may be given in evidence as part of the res gestae, so also statements of accompanying an equivalent act material to the issue and giving its a legal significance may be received as part of the res gestae. Number 7. What is order of examination of individual witness? Briefly define each. Section 4. Other an examination of the individual witness. The order in which the individual witness may be examined is follows. Direct examination is the examination in chief of witness by the party presenting him or her on the facts relevant to the issue. Section 6. Cross-examination. Upon the termination of the direct examination, the witness may be cross-examined by the adverse party on any relevant matter with sufficient fullness and freedom to test his or her accuracy and truthfulness and freedom from interest or bias or reverse and elicit all important facts bearing upon the issue. Section 7. Redirect examination. After the cross-examination of the witness has been concluded, he or she may be re-examined by the party calling him or her to explain or supplement his or her answers given during the cross-examination. On redirect examination, questions on matters not dealt with during the cross-examination may be allowed by the court its discretion. Section 8. Recross-examination. Upon conclusion of the redirect examination, the adverse party may re-cross-examine the witness on matters started in his or her redirect examination and also on other matters as may be by the court is discretion. Recalling witness after the examination of a witness by both sides has been concluded, the witness cannot be recalled without leave of the court. The court will grant or withhold leave its discretion as the interest of justice may require. Number 8. Briefly explain what is judicial affidavit. The GAR seeks to the Congress the ever increasing caseload in the country brought about by the high number of cases filed in each day. The lengthy procedures observed, the GAR also seeks to address any lost translation in interpreting the testimony of a witness. If the testimony was translated from local language into English. Number 9. An offer of compromise in criminal cases is an applied admission of guilt. What are the two exceptions? There are only two exceptions where compromise is not admissible as an implied admission of guilt in criminal cases. Number 1 is quasi-offenses, or acts defined and penalized under Article 365 of Revised Penal Code. Reckless imprudence and simple imprudence or negligence. Number 2. Those allowed by law to be compromised, their usual examples are found in the Revised Penal Code, particularly Article 266 of Revised Penal Code. The compromise that victim agreed to marry and indeed got married to the accused in a rape case, or compromise was made before the filing of the criminal complaint. Number 10. In order for evidence to be admissible, it must be relevant or competent when evidence relevant. What is evidence competent? Under Rule 128 Section 4, evidence is relevant is if it has a relation to the fact in issue as induced belief in its existence or non-existence. From this rule, we gather there are two competence relevance. First, relevant evidence has relation to the fact issue if there is relation between the evidence in material. Second, relevant evidence can lead us believe in existence or non-existence of the fact in issue. If the evidence supports our belief that alleged fact exists, then the evidence has probative value. Competence in addition to relevance admissible evidence must also competent under Rule 128 Section 3. Evidence is competent if it is not excluded by the law or these rules. A piece of evidence is disqualified by the law or the rules of court, then it is competent and will inadmissible. Number 11. What is leading question? When is it allowed? Section 10. Leading and misleading question. A question which suggests to the witness the answer which the examining party desires is leading question. It is not allowed. A. On cross-examination. B. On preliminary matters. C. When there is difficulty in getting direct and intelligible answers from witnesses who are ignorant, a child tender years, is feeble mind, or deaf mute. D. Of unwilling or hostile witness. E. Of witness who is adverse party, or officer, director, or managing agent of the public or private corporation or partnership or association which is an adverse party. 12. What is the misleading question? A misleading question is one of it which assumes as true as fact not yet testified to by the witness, or contrary that which he or she has previously stated. It is not allowed. 13. When circumstantial evidence sufficient to sustain conviction. Section 4. Circumstantial evidence when sufficient. Circumstantial evidence is sufficient for conviction if A. There is more than one circumstance. B. The facts from which the inference are derived or are proven. C. The combination of all the circumstances is such as produce a conviction beyond reasonable doubt. 14. This is distinguish burden of proof from burden of evidence. Rule 131, Section 1, burden of proof and burden of evidence. Burden of proof is the duty of party to prevent evidence on the facts issue necessary to establish his or her claim or evidence by the amount of evidence required by law. Burden of proof never shifts. Burden of evidence is duty of a party present evidence sufficient to establish rebut of the fact to issue established prima facie cause. Burden of evidence may shift from a party to the other in the course of proceedings depending on the exigence of the case. Number 15. What is the standard of proof necessary in civil cases? Rule 133, Section 1. Preponderance of evidence how determined in civil of evidence how determined in civil cases. The party having the burden proof must establish his or her case by the preponderance of evidence in determining where the preponderance or superior weight of evidence on the issues involved lies. The court may consider all the facts and circumstances of the case, the witness' manner of testifying, their intelligence, their means and opportunity of knowing the facts to which they are testifying, the nature of the facts which they testify, the probability or improbability of their testimony, their interest of want of interest, and also their personal credibility so far as the same may legitimately appear upon the trial. The court may also consider the number of witnesses, though the preponderance is not necessarily with the greater number. Criminal cases 133, Section 2. Proof beyond reasonable doubt. In the criminal case, an accused is entitled to acquittal unless his or her guilt is shown beyond reasonable doubt. Proof beyond reasonable doubt does not mean such a degree of proof excluding polity of error produces absolutely certain moral certainly unrequired, or the degree of which produce conviction and in prejudiced mind. 16. Administrative cases. Briefly define each. Rule 133, Section 6. Substantial evidence in cases filed before administrative or quasi-judicial bodies as fact may be deemed established if it supported by substantial evidence, or that amount of the relevant evidence which is reasonable mind might accept as adequate to justify a conclusion. Substantial evidence in the list of quantum of the proof required by the rules in applicable of administrative action, unlike judicial actions, do not include conducting full-blown trials, are the meant of conclude which greater speed an administrative body can render a decision on the basis that evidence presented is evidence which a reasonable mind might accept adequate of justify conclusion. This means that evidence can make reasonable person believe that allegation have occurred. Number 17. Define what are public documents. Rule 132, Section 19. Classes of documents for those purpose of their presentation in evidence documents are either public or private. A. The written official acts or records the sovereign authority, official bodies, and tribunals and public officers, whether of the Philippines or of a foreign country. B. Documents acknowledged before notary public except last will testaments. C. Documents that are considered public documents under treaties of conventions are forced between the Philippines and the country of source. D. Public records kept in the Philippines of private documents required by the law to be entered therein. 18. How do you prove present in the court of private documents? Rule 132, Section 20. Proof of private documents before any private document offered as authentic is received in evidence is its due execution An authority must be provided any of the following means. A. By anyone who saw documents executed or written. B. By evidence and genuineness of signature or handwriting and the maker. C. By other evidence showing its due execution and authenticity. Any other private documents need only be identified as which is claimed to be. 19. The original document rule states that when presenting a document as evidence, only original is admissible. What are the 4 exemptions? Section 3. Original document must produce exemption when the subject of inquiry is contents of the document. No evidence shall be admissible other than original documents itself except the following cases. A. When the original has been lost or destroyed or cannot be produced court without bad faith on the part of the offer. B. When the original is custody or under the control of the party against whom the evidence is offered and latter fails to produce it after reasonable notice. C. When the original consists of numerous accounts of other documents which cannot be examined in the court without great loss of the time and the fact suit to be established from them only general result of the whole. D. When the original is public record is custody of the public officer or is recorded in public office. Number 20. Who can become a witness? Qualification of witnesses. Section 20. Witnesses, their qualification except as provided in the next succeeding section. All the persons who can perceive and perceiving can make their known perception to others may be witnesses. Last one is 21. When is an extrajudicial confession sufficient to sustain a conviction? So, Section 3, extrajudicial confession not sufficient ground for conviction, and extrajudicial confession made by accused shall not be a sufficient ground for conviction unless corroborated by evidence of corpus delicti. So, that's all. Thank you.